The New York state law for non-governmental employers requires you to give a notice of pay rate to all employees at the time of hire, and then subsequently, if you change the rate of pay, other than in some cases just an increase in the pay rate, this has to be provided in writing. It has to identify things like what the regular payday is and the pay period. So that needs to be documented properly. There are specific fines for not providing that documentation to every employee. So make sure you do that. That has to then be signed by the employee and a copy retained by the organization. If you have someone who qualifies as a student or intern, you should have proper documentation for that. New York State has some specific requirements of what they expect. Regardless, you need to have as much documentation as you can to show that the person really qualifies as a student, what academic program they're involved in, whether they're getting credit. This exact documentation in a specific situation can vary, but if you don't have that type of documentation and someone were to challenge the fact that you weren't paying that person who is working for you, you may not be able to prove that they qualified for a student or internship exception. Wage statements have to be given out every time you pay your employees, and make sure that you're doing that. Normally that's a check stub, or these days an electronic check stub, but that is required. Notice of leave benefits. Again, non-governmental employers are required to have in writing their policies on vacation, holidays, sick leave, other paid time off, and hours. So if you don't have those types of things in writing and made available to employees, then the employee, regardless of what their classifications are, can come back and claim that they were entitled to some of these benefits. So again, these should be benefits likely limited to employees, not independent contractors, and you want to have it in writing so the employee can't just claim they were entitled to something else, where the Department of Labor, for example, will agree with the employee if the employer hasn't specified in writing what their benefit entitlements are. Finally, a termination notice. When you let any employee go, then you need to put it in writing and say, this is when you will receive your final pay, and this is the status of your employee benefits. This is technically a separate requirement from any requirements you have under COBRA to let people know about their health insurance continuation rights. So I normally recommend some sort of termination letter that includes something about you will receive your final paycheck on this date or the next pay date, whether you specify the exact date or not, and that you're no longer entitled to any employee benefits as of this date, sometimes mentioning that you will then also receive separate COBRA paperwork. Again, this is a requirement that is not going to specifically apply in the public sector because of the way New York's labor laws are written.